So naona tuanze kwanza na evidence law, then tuingie contract law. Yeah, so unapata kwanza tukiamua ni evidence law, pia ukiwa na any suggestion ama contribution, you can go ahead na to continue with it. So in the meanwhile, nimeona tuende tu direct kwa hearsay, alafu pia tuangalie exceptions of hearsay na provisions zina establish hearsay when it comes to Evidence Act as visible in your screen. So I believe at that time, so at the moment kila kitu iko clear. So acha niongeze volume. Okay, so if you ukiangalia volume iko sawa. Ukiangalia the notes za Mode anasema on hearsay evidence. Kwa nini nimeanza kuingia kwa hearsay? Because unapata ataleta scenario, then aseme deduce some relevant provisions za evidence law kwa hiyo scenario. So tukiamua ni kuingia kwa hearsay, niko naacha sasa kwanza to define as according to venye tu alikuwa anasema. Oh, nime lose connection. Oh, sasa nimerudi back. So ukiangalia definition ya hearsay, wanasema it refers to testimony, evidence given in court by a person other than the person who perceived it for the purpose of proving or disapproving the truthfulness of the fact in question. So I believe hiyo ndo definition tu ya hearsay, inatolewa na mtu mwenye perceive hiyo fact in question, na yet anajaribu kuprove and disapprove the truthfulness of the fact. So if you look at section 63, ndio anasema it draws now the essential requirement of direct evidence as admissible in courts. Na ukiangalia hiyo section 63, ndio acha ni project tuisome. Hiyo ndo starting ground ya when it comes to definitions of hearsay na why hearsay is not accepted before the courts of Kenya. So if you look at section 63, aya ndo hiyo, oral evidence must be direct. So remember, hearsay is not a direct evidence. So tunafaa kuangalia kwanza tujue what is the definition of direct evidence as defined by section 63. Na to be brief, wanasema ni evidence of a witness who says he saw it, that's a direct one. Pia wanasema witness mwenye anasema he had it. Pia unapata with reference to a fact which could be perceived by any other senses or in any other manner, the evidence of a witness who says he's perceived it by that sense or in that manner. So every human being anaweza kuwa na sense, maybe a smell, unaweza sikia pia harufu ya a dead person in another person's house, that's also a sense that you can perceive. So that is direct evidence. Then lastly, a certain example of direct evidence ni with reference to an opinion, to the grounds on which that opinion is held, the evidence of the person who holds that opinion, as the case may be, who holds it on those grounds. Lakini pia unapata the act pia imeendelea provide that the opinion of an expert expressed in any treatise commonly offered for sale and the grounds on which such opinion is held may be proved by the production of such treatise if the author is dead or cannot be found. So at times if the author is dead ama isipatikana, so just produce the treaty because it is generally known to people na ikuwe ni commonly offered for sale, like e.g. a medical book can serve this purpose well. So if ukiangalia subsection 3, acha ni mute kwanza nini WhatsApp messages acha kusumbua. Yes, so nilikuwa nasema if we go further to analyze section 63, hiyo subsection 3 inasema if oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it think fits, require the production of such material thing for its inspection. So I believe section 63 inatupea a ground why hearsay should not be admitted in Kenya, because hearsay is not part of direct evidence. So if we continue further by what Mode anasema is because the other essential feature, because ikikuja kwa hearsay, you cannot cross examine the person who perceived the information, the first one. So hapo tu hizo zingine zilikuwa tu general notes za kila mtu kujua, lakini sasa unapata kuna a landmark case lazima you must know, na the case inaitwa Subramanian versus DPP. So in this case, it's a landmark case because the appellant was charged and convicted of being in possession of firearms without lawful excuse. Alafu, in his defense now, this appellant asserted that he was acting under duress as a consequence of threats issued to him by a Malayan terrorist. When he attempted to state the contempt of the threats, he was overruled by the judge. So when this appellant alikuwa anajaribu kuongelea the contents of these threats, the judge overruled him na aka-appeal. He appealed the ruling because alipewa life sentence. Now he appealed the ruling of the judge, arguing that the judge should actually have listened to what the import of the threat was. And now the Court of Appeal found that the trial had disallowed the admission of the evidence on the basis that it was hearsay evidence. And now the issue before now this Court of Appeal is that whether the statement by the Malayan terrorist was hearsay evidence. And the Court of Appeal quashed the conviction, holding that the evidence by the appellant should have been admitted as direct evidence since the appellant perceived this particular evidence. So unakumbuka hapo juu kwa nini tulianza na section 3, because nimekwambia it can be perceived. If you look at section 63(2)(c), with reference to a fact which could be perceived by any other sense, that is a direct evidence. So in this court, they were referring to section 63(c), when they said that information ilikuwa direct evidence. Now the Privy Council characterized hearsay evidence as follows. So they went again to establish the definition of hearsay in a more understandable manner. Now akapata that evidence of a statement made to a witness by a person who is not himself called as a witness may or may not be hearsay. Even point number 1 that the court gave forward. It is hearsay and inadmissible when the object of the evidence is to establish the truth of what is contained in the statement. So if the main purpose of you giving this hearsay ni ku establish the truth, the veracity of that information to be true, itakuwa hearsay. But if the main aim unataka tu the court ijue that this information indeed it was provided and you don't want to go into the truthfulness of that statement, then that will be admissible before the courts. And now there was also another case in pia aligive, and you can also look at it, naitwa Myers versus DPP. So hiyo case pia ina give emphasis kwa Subramanian versus DPP. So if you can call that Subramanian versus DPP, at least ndo the landmark case hapo. Then you can also look at Republic versus Ahmad Abolfadi and another, a 2019 case, Kenya Law Report, and you distinguish clearly between admission and confession. But we won't go to delve into admission and confession because I want us now to look at exceptions to hearsay, then tutaanza to discuss admission on its own, confession on its own, what you mean by out-of-court confessions, and etc. So it will be a flowing, systematic approach to this. So at that point, tushaelewa what's hearsay, tushaelewa what's direct evidence, na the reason why a hearsay is not admissible before the court, because you cannot cross-examine that person who perceives it. Now the next part is, what are the exceptions that constitute a hearsay evidence? And the exceptions are discovered ziko under section 33 of Evidence Act. Let me fungua because I saw some zikipop hapo. Section 33. If you look at the teacher's note, wanasema, because ana list down, anasema number 1, itakuwa admissions, na zimeprovediwa for under section 17-24. We'll have a look on admission ikikuja on its own, hizo sections. Then unapata pia aka list kuna res gestrae. Tutaangalia pia what constitutes res gestrae, landmark cases in res gestrae doctrine. Alafu pia unapata ameongelea about confessions. Tutaongelea what constitutes a confession, what do you mean by extra-judicial confession. We'll also look at statements made against the interest of a maker. At least at section 33 mnaona hizo zingine zimeanza kupop up under section 33. So pia unapata kuna statements relating to existence of relationship by blood marriage, and the statement should have been made before the issue is made. Hapo hiyo point haikuwa clear kwa notes za model, lakini under section 33 I believe hizo vitu zote mnaona hapo are exceptions to what is hearsay. And relating to existence of relationship ni yenye unaona hapo chini E 33E unasema relating to existence of relationship, its definition pia imetolewa hapo vizuri. And an opinion as to public right or custom pia ni another exception of hearsay. Then kuna statement made by a person who cannot be called as a witness as provided under section 33 of Evidence Act. So I believe if we now look at section 33 in its whole, tutaanza kuelewa these exceptions, then we from there tuingia admission, then confessions, then res gestrae tumalizie. So if you look at section 33 wanasema statement by deceased person will be admissible because in this scenario statements written or oral or electronically recorded of admissible facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured or whose attendance cannot be procured, that the act ilikuwa na repetition, without an amount of delay or expense which in the circumstances of the case appears to the court unreasonable, are themselves admissible in the following cases. So if the person is dead ama ilimekiwa na mtu hawezi kuwa procured at the time without causing a necessary delay of time, itakuwa admissible. Na number one ni relating to cause of death. If that statement ilikuwa ina resort to a cause of death ya huo msee, then itakuwa admissible. If the statement was made in the course of business, when the statement was made by such person in the ordinary course of business, and in particular contain entry or memorandum made by him in the books or records kept in the ordinary course of business, it will be admissible against the interest of a maker. Pia ni another area where a statement can be admissible and it will not constitute what we call hearsay. When the statement is against the pecuniary ama monetary value or proprietary interest of the person making it, or when, if true, it will expose him or will have exposed him to a criminal prosecution or to suit for damages, itakuwa admissible before the courts. And an opinion as to public right or custom, pia ni itakuwa one statement where it's admissible before the courts. Then if the statement also relates to existence of a certain relationship, if the statement relates to family affairs, if also the statement relates to a transaction creating or asserting a custom, as mentioned under section 13, and finally made by persons and expressing feelings, those are also exceptions when it comes to hearsay, na zimepewa its own section to give effect to section 63 on direct evidence. Then if we also look now on what constitutes an admission as an exception to hearsay, then we jump now to a blog in Kenya Law Reports yenye inaongelea now on admissions in Kenya in its full capacity, where we'll understand what it means by admissions. So if I click on the admissions in Kenya part, we'll find the following. What is an admission first? So we start by definition. So section 17 of Evidence Act provides that an admission is a statement, oral or documentary, which suggests any inference as to a fact in issue or relevant fact, and which is made by any of the persons and in the circumstances mentioned in the following analysis. So the following circumstances ndio zina provide, they will make you understand what we mean by a definition when it comes to section 17 of the Evidence Act. Then the next question unafaa kujiuliza, who are the persons eligible to make an admission? So section 18 provides for the following people as eligible to make an admission, and they include, number one, statements by party to suit or agent or interested person when it comes to a suit or matter before the court, itakuwa wako eligible to make an admission. Person who have any proprietary or pecuniary interest in the subject matter of the proceeding, they can also make an admission. Persons from whom the parties to a suit have derived their interest in the subject matter of the suit, are also eligible to make an admission. And if you look at section 19, wanasema pia statements by person whose position or liability must be proved as against party to suit. It's also an area where itachukuliwa to be eligible to give an admission. Then finally, if you look at section 20, wanasema statements by person expressly referred to by party to suit. So if one party in the suit anasema, I want this person to come and admit on this information, hapo amekuwa expressly referred to by a party to suit, and that is section 20. Then the next question unafaa kujiuliza, who can't make an admission in Kenya? If you look at section 18 of Evidence Act, wanasema statements made by parties to suits suing or sued in a representative character are not admissions unless they were made while the party making them held that character. This section proves to be a little bit confusing to students, lakini unapata if you break it down you'll understand it clearly. Wanasema statements made by parties to suits suing or sued in a representative character. So if they have a certain representative, like let's say it's a pro bono advocate ama ni a family member, they ana make this admission, haitakuwa admission, haitachukuliwa to be admissible unless they were made while the party making them held that character, unless this auntie of maybe this convict ndiye alikuwa na ameamua ku give this information. Sasa unapata now it will be used against that person being sued ama suing, wakati sasa atajitambulisha kwa koti like I have the representative capabilities to represent this person. Then allow me to add someone, then nirudi